Good evening, everyone. I'm Abhinav Shukla, the host of today's session. I, on behalf of the whole team of Just Corpus, welcome you all in today's session on human rights, climate change, and environmental protection, a South Asian perspective. Before we delve into today's discussion, let me provide a brief introduction of Just Corpus and the eminent guest speaker of the day. Just Corpus is a body of legal professionals who have come together to bring various aspects and chains of law under a single umbrella. Just Corpus, an edtech platform set up in 2020, has a wide reach of 600,000 clicks per month on an average basis on a website www.justcorpus.com. The inspiration was derived from the ever-growing need for law students. Just Corpus has also incorporated an interdisciplinary journal and a multidisciplinary journal as its subsidiaries, named as Just Corpus Law Journal and the International Journal of Law Research, Education, and Social Sciences. Now, turning our attention to today's focal point, we are privileged to have Ms. Neha Tripathi as an esteemed guest speaker of the day. We welcome you, ma'am. Ma'am is an assistant professor of law at Mahindra University. Prior to joining Mahindra University, she worked at Maharashtra National University Aurangabad, National University of Study and Research in Law Ranchi, and School of Law Sarda University. She is also a PhD scholar at National Law University Delhi. She has more than 7 years of teaching experience. She has a specialization in constitutional law and human rights law. She currently engages courses on administrative law and moot court. Her areas of interest include comparative constitutional law, South Asia constitutionalism, constitutional interpretation, judicial processes, and administration law. She has presented various papers at global forums like 9th Asian Constitutional Law Forum organized by Institutum Jurisprudentia, Academia Sinesia, Taiwan, Hybrid ISCL Round Table in Copenhagen, Denmark, the impact of digitalization on constitutional law, Symposium on Constitutionalism and Public Law, Global South Perspective, Indonesia, 4th Indonesian Constitutional Court International Symposium, amongst other. Recently, she participated in the doctoral School on Asian Comparative Regionalism organized by University Erlangga, Indonesia. She has successfully completed Winter School on Federalism and Governance 2022, Federalism and in Emergency organized by UREC Research and Summer Course on Liberalism, infected revisiting political and socio-legal thought in the aftermath of COVID-19, organized by Central European University, Budapest. She was awarded Emerging Law Professor of the Year 2020 by Indian National Bar Association. Without further ado, I would like to hand over the floor to ma'am for her insights on the topic. Once again, we welcome you, ma'am.
Thank you, Avinav. Thank you, Ayush, for inviting me. So today's session is basically on human rights, climate change, and environmental protection, a South Asian perspective. I'll just be sharing a PPT with everyone so that we can start the session for today. I hope I'm audible properly, right?
Yes, ma'am.
Okay, thank you. So, with regards to the topic, introducing the topic for the audience today, the quality of human life is contingent upon ecological conditions. Most likely, some human rights will be affected negatively quicker than others. And the right to life belongs to this group, which is called as the supreme right, from which no derogation is generally permitted, which is right to life. It has profound importance both for individuals and for society as a whole. It is most precious for its own sake, but it also serves as a basic right, facilitating the enjoyment of all other human rights. We need a receptive environment to enjoy our human rights in the first place, and without the right to life guaranteed, all other human rights are basically meaningless. A complex relationship exists between environmental factors and socio-cultural dynamics and economic progress. The notion of environment is no longer concerned with just natural surroundings or habitats, but is more about a safe and a stable environment today, which is supported by a favorable climatic order that impacts upon people's organic state and their psychological and social well-being. Environmental phenomena, either prolonged or sudden, have considerable social, psychological, and ethical impacts, and thus cannot be understood from economic and technical standpoints alone. Rather, the social dimensions play a very important role today. No wonder environment and climate change issues have become so significant in the world today that government, regional bodies, and international organizations are agonizing over ways to control the continuously deteriorating situation. Development will remain an illusion and serve limited purposes if environmental sustainability is not factored into strategies for economic growth and social advancement. The environmental and health consequence of climate change, which disproportionately affects low income countries and poor people in high income countries, profoundly affect human rights and social justice. Environmental consequences include increased temperature, excess precipitation in some areas, drought in some areas, extreme weather conditions, and increased sea level. These consequences adversely affect agricultural production, access to safe water, worker productivity, and inundating land or making land uninhabitable or uncultivable, which forces many people to become environmental refugees. And therefore, these environmental and health concerns or the consequences which arise from them threaten civil and political rights on one hand and economic, social, and cultural rights on another, which includes right to life, access to safe food, water, health, security, shelter, and culture. On a national or a local level, those people who are most vulnerable to adverse environmental and health consequences of climate change include poor people, older people, people with chronic diseases and disabilities, or those who are residing in areas with a high prevalence of climate related diseases. On a global level, we see much inequity when it comes to greenhouse gases. So there, with regards to low income countries which produce least greenhouse gases, they are much more adversely affected by climate change than high income countries which produce substantially higher level of greenhouse gases. Yet they are still less affected than the low income countries. In addition, the low income countries have far less capacity and capability to adapt to climate change in comparison to higher income countries. This brings us to understanding the interconnection of human rights and climate change. This raises a very pertinent and a prevalent question for today's session, which is whether a human rights framework is appropriate to respond to environmental challenges which are associated with globalization. And this question continues to be debated today by policymakers, academicians, and even judicial courts, including constitutional courts all across the world. Now, some find that the concept of individualism, which underlies the human rights framework, is at odds with the collective concern of environmental law, or find that in the divergence between intergenerational equity and intragenerational equity, there is no single core value which undermines human rights. Now, other point which needs to be taken into consideration today in form of an argument is that the civil and political rights enjoy a special place in the collection of other human rights. So inclusion of environmental rights gives them a cultural legitimacy, and they generally lack cultural legitimacy unless and until you holistically understand it from the perspective of civil and political rights. So, even the debate which surrounds the environmental dimension of first generation human rights is not determinative today, because the procedural rights, like right to access of information or to become a party to legal proceedings, are equally as important as enforcement of rights are concerned. Historically, the advancement of human rights predates the environmental uh, movement by many centuries, and therefore both have in large part evolved separately in response to specific threats to human liberty and the planet. However, with the advent of Universal Declaration of Human Rights in 1948, which came into existence after the conclusion of the Second World War, it signaled a new era in which we see a plasticity of human rights emerge as a durable phenomenon. Attempts to read basic corpus of human rights in an ecologically literate manner has thus to be seen in the context of historical continuity, in which two separate streams of thoughts have merged together and put dignity of man on a much more stronger footing. This takes us to defining human rights in the context of climate change. So, according to UNEP suggests that climate cases to date fall in either of the six categories. First, climate rights, second, domestic enforcement, third, keeping fossil fuels in the ground, fourth, corporate liability and responsibility, fifth, failure to adapt and impact of adaptation, and sixth, climate disclosure and greenwashing. Now, with respect to defining human rights in context of climate change, we need to understand what are the key elements which are important for the discussion today. So the three key elements which we have to look forward to today is the conceptual framework, regional vulnerabilities, and legal recognition. In terms of conceptual framework, human rights generally encompasses fundamental entitlements of individuals, which are increasingly being threatened today by the climate change impacts such as extreme weather, rising sea levels, and resource scarcity. And this is very much pertinent to be discussed, especially in context of South Asia. Regional vulnerabilities in the context of South Asia facing unique challenges due to its geographical situation and socio-economic condition, making the protection of human rights essential in addressing the climate-induced displacement, health risks, and food insecurity. Legal recognition, because there is a growing recognition within international law that climate change can violate human rights, prompting South Asian nations to integrate human rights consideration into their climate policies and environmental protection laws. Now, having said that and having understood for today that what are the core elements which we are going to talk about in the next few slides, we have to now discuss a little bit about internationalization of human rights. Now, when we talk about internationalization of human rights, obviously the history of human rights development or evolution does not just start with Universal Declaration of Human Rights in 1948. So, for today's purpose, I'm not going to deal in detail the historical evolution of human rights, because most of us are aware about the traces of Magna Carta, the French Declaration, the American Bill of Rights, and then the UDHR. However, the UDHR, when it came into existence in 1948, it had its own set of challenges. It was proclaimed as a resolution of United Nations General Assembly, which meant that as per Article 11 of the UN Charter, it was merely a recommendation. And as a result of that, it was not binding on the member states. This notwithstanding, the Universal Declaration soon acquired a life of its own. It started to soon resonate in national constitutions, state practices, and the jurisprudence of national courts. Yet it took 18 years to transform the declaratory content of UDHR into hard and binding law, with regards to adoption of ICCPR and ICSCR and optional protocols to both the conventions. ICCPR, which is International Covenant on Civil and Political Rights, ICSCR, which is International Covenant on Economic, Social and Cultural Rights, came into existence in the year 1966. The International Bill of Rights, as they are collectively called, stood completed. However, the Universal Declaration, as it stood at that point of time, had still to be implemented properly. In Europe, the European Convention of Human Rights was adopted in 1950, and as a result of that, the European Commission on Human Rights was established, which was later on abolished, and the European Court of Human Rights was also established to implement new human rights regime in Europe. Parallelly, in America, there was a parallel development which was going on in form of American Convention on Human Rights 1969. With regards to American Convention on Human Rights, the Inter-American Court of Human Rights was established, and the Inter-American Commission of Human Rights was also established to enforce human rights. In about 2 decades since the adoption of 1948 Universal Declaration of Human Rights, the protection of human rights had transcended to a matter of legitimate international concern, and regional priorities were well developed beyond the defense of domestic jurisdiction that transgresses state, which had been traditionally developed as a concept of state sovereignty before the UN Charter had been brought into existence to shield their human rights abuses. South Asia by then had only emerged from the era of colonization. And as a result of that, it had no significant impact or contribution when UDHR was being drafted. This takes us to the major development in the field of environmental law and human rights. So the Stockholm Principles, which was developed during the International UN Conference on Human Environment in 1972 in Stockholm, Sweden, it had a much more broader participation because by then the Asian and African countries, most of the countries were already independent. So the UDHR, which had preceded way back, was led by the developed countries. And the United Nations, when UDHR was being drafted, only comprised of 58 nation states. However, Stockholm included all the newly independent African Asian countries. From this perspective, the development towards international efforts to protect the environment were not handicapped by the non-participation of the emerging decolonized states. The roots of internationalization of protection of environment are found in a more universal consensus between the developed and the developing countries. The third world by then had arrived on the international stage to influence global policies and practices, and it was a measure of the growth in the stature of South Asia that India's Prime Minister Indira Gandhi at that point of time had dominated the attention and headlines at the Stockholm conference by her campaign called as Project Tiger. Now, with regards to the movement towards the environmental protection regime in the international arena, we come down to Rio Declaration. However, before Rio Declaration, in 1982, the UN General Assembly adopted the World Charter for Nature. The Rio Declaration, the United Nations Conference on Environment and Development, in short, we refer to it as UNCED. The Rio Declaration on Environment and Development reinforced the Stockholm Principles and the World Charter for Nature. The Earth Summit, as it is generally called as, represented a high watermark in international efforts to prioritize sustainable development. So, Agenda number 21, the Convention on Biological Diversity, and the Statement of Principles for the Sustainable Management of Forests were the other landmark achievements as an offshoot of Rio Declaration. Next came the World Summit on Sustainable Development in Johannesburg, South Africa in 2002. The World Summit on Sustainable Development prioritized water, energy, health, agriculture, and biodiversity, and for the first time laid down timelines for the accomplishment of certain stated goals. But the most remarkable accomplishment in Johannesburg was the pioneering initiative of UNEP to organize a global judge symposium on sustainable development and the role of law in recognizing apparently the role of judiciary in many jurisdictions, particularly South Asia, to showcase that how judiciary has been playing a proactive role in protecting environment. Rio Plus 20, which came up in 2012, was the most recent summit in the decennial calendar of sustainable development. And once again, Rio Plus 20 acknowledged the growing role of judiciary in issues regarding sustainable development in holding the World Congress on Justice, Law and Governance as a parallel event. Other notable developments which happened at the back end have been the Earth Charter, which came up in 2002, and IUCN Draft International Covenant on Environment and Development, which came up in 1995. To the developing countries, the most important areas which were identified to be worked upon were number one, sovereignty over natural wealth and resources. The second important core area was right to development. The third core area which was identified was eradication of poverty. Fourth area was consumption patterns of the north. Fifth was capacity building. Sixth was looking into waste trade. Seventh was rescheduling or writing off debts. Eighth was transfer of resources. Ninth was transfer of technology. And tenth was harmful activities of transnational corporations. The Catalogue of Human Rights, which were proclaimed as universal by the United Nations in 1948, were readily owned by South Asia at the highest level of a constitutional commitment. In fact, the constitutions of India, Pakistan, and Bangladesh, all of which post date the Universal Declaration, elevated these rights to the level of fundamental rights, for the enjoyment and protection of which every person could directly approach the constitutional courts. And in some exceptional circumstances involving public interest, even the highest apex court of the countries could be approached. This was a unique incorporation of human rights in the basic law of the land through the writ jurisdiction. The superior courts of South Asia have now begun to champion the right based dignity of human beings. Now, this takes us to the next discussion for today, which is with regards to understanding. Sorry, just a second. This takes us to the discussion for today, next important discussion for today, which is looking at climate concerns as a peripheral issue to the mainstream environmental litigation in India. Now, as we look at it, most of the countries in the South Asia have been reading right to life expansively to include right to clean and healthy environment. However, what about incorporating an element of climate change within the jurisprudence of either right to life or right to healthy environment? In India, in a very famous but yet an unsuccessful case, which came up in 2019, was heard by NGT, titled as Ridhima Pandey versus Union of India. The applicant Ridhima Pandey had attempted to highlight before the National Green Tribunal the link between human rights and climate change. So she tried to highlight that how and what kind of adverse health impacts are there of climate change on human beings. So it was tried to bring to the attention of the tribunal that climate change has adverse impact on food and water security, which can also lead to crop failure, ocean acidification, water and soil salinization, and species extinction. However, this case does not establish a direct link between human rights and climate change. The tribunal, very interestingly in this case, dismissed the petition by observing that it does not have a reason to presume that the Paris Agreement and other international protocols are not reflected in the policies of the Government of India or are not taken into consideration in granting environmental clearances. However, much recently in 2024, the Indian Supreme Court has passed a very landmark decision with regards to climate change, human rights, and environmental protection. I'll be dealing with the same in few minutes' time. Now, with this judgment in mind, we now go on to discuss about looking at understanding environmental protection as a human right. Now, what does this actually deal with? So, this can be studied at three levels. First, fundamental right recognition. Second, interconnectedness of rights. And third, legal framework and advocacy. With regards to the first point, I would like to highlight that environmental protection is increasingly being recognized as a fundamental human right, which is being considered as essential for realization of other collected rights like right to life, health, and adequate standard of living, particularly in the context of South Asia's vulnerable population. With regards to looking at the bundle of rights and how they are interconnected, the degradation of environment basically affects the human rights directly. Take, for example, pollution, deforestation, climate change. All of them collectively threaten access to clean air, water, food security, necessitating a need for having a holistic approach to human rights advocacy that includes environmental considerations. Looking at legal framework and advocacy factor, various international and regional legal frameworks advocate for integrating environmental protection into human rights regime. And today, the demand is to have a much more stronger human rights regime with regards to environmental protection in place. Moving on to the next discussion for today, the impact of climate change on vulnerable population. Looking at the impact of climate change on vulnerable population, it hits them at various levels, including displacement and migration, including the potential health risks which are involved, and the socio-economic inequities which result out of it. So if we look at displacement and migration, climate change basically furthers displacement in South Asia because of rising sea levels and extreme weather conditions, which are forcing the vulnerable populations to migrate, leading to loss of livelihood and increased poverty. Looking at health risk, there are potential health risks involved with regards to climate change, including incidents of vector-borne diseases, malnutrition from food insecurity, and mental health issues stemming from environmental stress. Economic inequality is a result of climate change, which leads to again displacement. It is related to displacement and migration. It affects the marginalized group in South Asia because they lack resources generally to adapt or recover from climate related disasters, entrenching existing inequalities. Now, with this discussion in mind, what are the legal frameworks which support human rights in environmental context? So it could be again studied from three different perspectives. First is international treaties, second is national legislations, and third is judicial precedent. First one, we have already discussed that how international treaties uh, even including Paris Agreement and the Convention on Biological Diversity, they emphasize the importance of integrating human rights into environmental governance, providing a legal basis for protecting vulnerable groups in South Asia. Looking at national legislation, South Asian countries are now increasingly adopting the internationally approved practices with regards to recognizing right to healthy environment, which serves as a basic model or a framework for holding governments accountable for environmental degradation. Looking at judicial precedents, we will be studying few cases from South Asia, important landmark judgments, which have acted as a precedent for linking environmental protection with human rights, reinforcing the role of judiciary in safeguarding citizens' rights against state action that harm the environment. Now, if we look at climate change in South Asia, a lot of areas have to be looked at holistically. South Asia is one of the world's most vulnerable regions when it comes to climate change. It features varied landscapes that include arid areas, which are subjected to severe droughts, low lying coastal areas, which is subject to flooding, and even coastal erosions, islands whose continuous existence is threatened by the projected rise in sea level, tropical zones, which are subject to increasingly frequent and devastating cyclones, and mountainous ranges, which is affected by the melting of glaciers. Now, mitigation policies have played a very pivotal role in reducing carbon emissions and, in turn, the human impact on the climate, whereas adaptation policies can make the population and looking at the vulnerable groups, the economy can be made more resilient in the face of changing climate. So, action on both the front is the need of the hour today. A key global coordination mechanism in reducing carbon emission is the Paris Agreement and the countries' nationally determined contribution to have lower emissions. However, even after meeting these commitments, it is likely to be insufficient to achieve the needed reduction in the carbon emission and to keep global temperature increase under check. So the requirement is to keep the global temperature check below 2 degrees Celsius above pre-industrial level. Now, as the largest carbon emitter in South Asia, India plays a very pivotal role with regards to having a leadership role in the South Asian region. Now, what is the global mitigation strategy which has been adopted? So, the United Nations Framework Convention on Climate Change, which is referred as UNFCCC, was entered into force in the year 1994. Now, its aim is to prevent dangerous human interface with the climate change. As of 2019, it has near universal membership, and 197 countries have ratified the convention, which are known as parties to the convention. Building on the convention, the Paris Agreement charts a new course in the global effort to combat climate change and adapt to its effect. The Paris Agreement entered into force on 4th of November 2016. As of 2019, 187 of 197 parties of the convention had ratified the Paris Agreement, and today there is universal acceptance of the Paris Agreement. Now, additionally, the Paris Agreement also aims to impact to keep in check the impact of climate change by including enhanced support to assist developing countries. Now, under the agreement, all parties are required to put forward their best effort to have through their nationally determined contributions, which are referred as NDCs, to strengthen their efforts in the years ahead. This include the requirements that all parties must report regularly on their emissions and their implementation efforts which they have taken to reduce the carbon emission. Now, there is a considerable heterogeneity in the type of commitments which have been made by 6 South Asian countries if we look at them. For example, India has unconditionally committed to 33 to 35% reduction in emission intensity by 2013 compared to 2005 levels. Bangladesh has committed to a 5% reduction in greenhouse gases emission by 2030. Maldives has committed to conditionally reduce 26% of its greenhouse gases. Nepal has 2030 target, but a conditional 2050 target. Nepal has no 2030 targets, but a conditional 2050 target to reduce fossil fuel dependency by 50%. On the other hand, Bhutan is notable to being one of the 2 countries in the world that is already carbon neutral. So Bhutan has made the commitment to remain carbon neutral in 2009, and despite their status as a small mountainous developing country, they have remained consistent to that promise, and their nationally determined contribution has renewed this commitment to remain carbon neutral country going forward. And it is expected that even in the foreseeable future, Bhutan is going to follow that track. Now, by understanding the climate change policy and the mitigation strategies and how they have been undertaken by the South Asian countries, now we will be discussing few judicial trends in South Asia by looking at the landmark judgments as has been delivered by the constitutional courts in the countries of India, Pakistan, Sri Lanka, Nepal, and Bangladesh. With regards to India, advent of public interest litigations brought a much difference to homogeneously understanding right to clean and healthy environment from the perspective of right to life. In addition, the 42nd Amendment introduced Article 48A to the Directive Principles of State Policy, and we are all aware about few very important landmark judgments which have been delivered by the Supreme Court of India over a period of years. Like, for example, I would like to discuss about Subhash Kumar versus State of Bihar judgment. The judgment was delivered in 1991, and it talks about right to life and how right to life includes right of enjoyment of pollution free water and air. We also had, on the other hand, cases like Charan Lal Sahu versus Union of India and MC Mehta versus Union of India, 1990 and 1998 decision. Also, I would like to cite Kirloskar Brothers versus ESI Corporation case of 1996, wherein right to life was used expansively to diversify itself to include right to healthy environment, including right to survive as a species, quality of life, right to live with dignity, and right to livelihood. So the Supreme Court has been expanding and relying on Article 21 of the Indian Constitution to read environmental laws or environmental rights within its pretext. However, there have been various cases over a period of years on environmental concerns and developmental activities. Take, for example, mining, construction of dams, amongst other. So we have cases like Goa Foundation judgment, Odisha Mining Corporation versus State of Odisha, Narmada Bachao Andolan case, Tehri Bandh Dam case. Then we had Godavarman, TN Godavarman cases, Banwasi Seva Ashram judgment, Society for Protection of Silent Valleys. These cases showcase that the Indian Supreme Court over a period of years have been also reading environmental concern with regards to developmental activities. Recently, in 2024, in MK Ranjit Singh and others versus Union of India, the Supreme Court ruled that people have a right to be free from adverse effect of climate change. The ruling of the Supreme Court was rendered in response to a writ petition which was brought by a conservationist who sought protection for two endangered species, namely the great Indian bustard. And in this case, the court had a very holistically talked about that Article 21 also talks about access of environment and how, what is the impact of climate change. So it was the first time that the court actually took into consideration the attribute of climate change and then looked at it holistically from a constitutional perspective. The court also cited the fact that they have a fiduciary duty to implement international agreements and treaties, and it was already held by the court in the case of Apparel Export Promotion Council versus AK Chopra judgment. Uh, there were various other cases which the court relied upon in MK Ranjit Singh versus Union of India cases. So the court relied on ECHR judgment. The court relied on State of Netherlands versus Argenta Foundation case, which is a very famous case of 2019. It is a very landmark climate case in which the Dutch Supreme Court ruled that the government must reduce the greenhouse gas emission by at least 25% by the end of 2020 compared to 1990 levels. The court had based its decision on ECHR cases, stating that failing to take sufficient action by the government against climate change poses a real threat and an immediate risk to human rights, especially right to life and well being. This ruling set a global precedent for climate litigation. When we come down to a country like Bangladesh, again, Bangladesh, like India, does not have a very specific article which talks about right to healthy environment. So we have to rely on two articles in the Constitution of Bangladesh, which is Article 31 and Article 32. Article 31 and Article 32 of the Bangladesh Constitution deal with rights of every citizens to be protected from action which is detrimental to life, liberty, reputation of property. And Article 32 talks about no person shall be deprived of life and personal liberty save in accordance with law. Very famously, in the case of Farooq versus Bangladesh in 1996, the Supreme Court of Bangladesh highlighted that the constitutional right to life does not extend to does extend to include right to safe and healthy environment and include anything that affects life, public health, and safety. Further, in 1999, in the case of Ain O Salish Kendra versus Government of Bangladesh, this case recognized the importance of protecting wetlands and natural water bodies in urban areas. And further, in the case of Hassan versus Bangladesh and others in 2016, the Supreme Court of Bangladesh ordered the removal of industries operating illegally within the designated areas around the Sundarbans, which is a UNESCO World Heritage Site. Coming down to Pakistan, in Pakistan, right to life is guaranteed under Article 9 of the Constitution, and it had been confirmed very famously in the Zia versus WAPDA case of 1994. In Zia versus WAPDA judgment, right to life was held to include right to live in unpolluted environment. The same was reiterated in other cases like the Employees of Pakistan Law Association versus Ministry of Works in 1994 and Amanullah Khan versus Chairman Medical Research Council and Pakistan Chest Foundation versus Government of Pakistan. These cases discussed about right to adequate level of living and right to safe and unpolluted drinking water. In the case of Leghari versus Federation of Pakistan in 2015, that case is a very landmark judgment by the Pakistan Supreme Court on climate change litigation. The court recognized government's failure in this case to implement national climate change policy as a violation of fundamental right. Further, in 2019, in Muhammad Wasim versus Federation of Pakistan, the Supreme Court addressed the issue of air pollution in the city of Lahore and ordered the government to take immediate measures to reduce air pollution, emphasizing right to healthy environment. Coming down to Nepal, now Nepal has a much recent tryst with the constitution, so it is yet to be seen that how the constitutional right to environment would fare out in future. However, we have two important judgments from Nepal, which is Prakash Mani Sharma versus Government of Nepal 2003 judgment and Surya Prasad Sharma versus Godavari Marble Industries 1995 judgment. In Prakash Mani Sharma versus Government of Nepal in 2003, the Supreme Court of Nepal emphasized the need for effective implementation of environmental laws and policies. The court directed the government to enforce stricter regulations for industries which were causing pollution. In Prasad Sharma versus Godavari Marble Industry, the Supreme Court of Nepal highlighted the importance of environmental rights and ordered the closure of a marble factory that was causing environmental degradation. Coming down to Sri Lanka, we have one case from Sri Lanka, which is Balankulamma versus Secretary of Ministry of Industrial Development 2000 judgment. The Supreme Court of Sri Lanka, in this is also called as the phosphate judgment. In the phosphate case, the Supreme Court of Sri Lanka ruled that a government agreement to mine phosphate in an environmentally sensitive area is not correct, and therefore the court ruled against it, and the judgment emphasized the need to protect natural resources for future generation. So now that we have holistically analyzed the legal framework, we have also looked at the key core areas which needs deliberation. What are the lacunas which are existing? What is the international regime? What are the national regimes? How the constitutions have been used? And let me also point on record that countries like India, Pakistan, and Bangladesh have a developed uh, rules with regards, today they have developed rules with regards to public interest litigations, and the courts have been relying on public interest litigations very heavily to basically provide justice in case of environmental concern matters. So with this, I would now like to conclude the discussion for today. The crucial reason as to why a stronger focus is needed today on a human right based approach is its potential to function as a political and ethical imperative. Now, if we begin to acknowledge the idea that climate change violates fundamental human rights, and will do so on an incalculable basis, then this leads to numerous lawsuits and compensation claims against the government, which might contribute to a directly needed breakthrough in politics. And actions can turn into legal obligations, thereby again providing a way to influence or to even improve climate related policy matters. Now, sustainable development today calls for plans and actions on part of the countries that transcend nations per se, and there should be a sort of a partnership between countries to resolve this issue, because everybody is affected by climate change, right? However, the political, geographical, and economic landscape of South Asia is what makes it much unique. So, therefore, having a sustainable development policy which caters to the emerging contemporary needs is a challenging issue. Now, as I have pointed out in the slide, in spite of the fact that SARC exists, the relationship between most of the South Asian governments have not progressed yet, right? To a stage where they have a mutual trust and their interest is sort of evident. And therefore, these nations do vary hugely in terms of size, population, and their political stability. Like if you look at South Asia, India seems to be a more stable political entity than other countries like Pakistan or Sri Lanka or Bangladesh. We all know what is happening in the neighboring countries. Now, if we begin to acknowledge that the climate change violates fundamental human rights, then the serious threat of climate change has been impacting a lot on other important rights like right to livelihood, lifestyle, and even the location of citizens. So, the proximity which the South Asian countries have, that allows climate change migrations to move easily to other neighboring countries. And this complicates the relation among them as well. So, numerous statements and agreements they have been reached over a period of years between these countries, that how would they like to promote environmental protection, but yet they remain neglected and seldom they are revived to address the emerging issues and needs. So there is an inconsistency in the strategy and the actions that persist today. Moreover, clubbed with it, South Asia is also very prone to natural disasters, and they are very frequent in the South Asian regions for decades. So, therefore, there is a huge demand for a strong response from the government, which would also focus on rescue and rehabilitation process, and would have a sort of a preemptive approach towards the issue. So, environmental governance in most of the South Asia has by and large been a much state dominated issue, with direct intervention only through regulatory practices and strategies. Undoubtedly, the judiciary has played an active role in relation to having a framework in place, but yet the governmental approach, which more follows the sound of good governance model, more has to be done with regards to incorporating the stakeholders, right, in the process. So having said that, a lot of other transboundary environmental governance issues can also be looked into to resolve this problem by the South Asian countries, and it needs to be designed, like the policy needs to be designed keeping in view the uniqueness, the cultural differences of each of these countries and the sub regions between them. And there needs to be a strong political commitment and leadership with regards to tackling the issue of human rights, environmental concerns, and climate change today. So, with this, I would like to end my lecture. And it was a pleasure to have been there to speak about such an important and pertinent topic, which concerns every one of us. Thankful to the team of Just Corpus, Ayush and Abhinav. Thank you for inviting me. I am now open to any questions if the audience has for me.
Thank you so much, ma'am, for sharing your valuable insights. I personally learned a lot, and I believe that the audience have the same feelings. Now we are open to question and answer rounds. Uh, so I do have some of the questions which I will reiterate, and you can answer them afterwards, ma'am. Ma'am, the first question that I have with me is, what are the problems that may affect the laws concerning our human rights?
Okay. So, see, with regards to the first question which you asked, I already answered it to a certain level during my lecture. That most of these countries, because they are politically very unstable, there is a lack of inadequate legal framework, right? So, there is still like the existing laws which these nations have, they are not fully developed to recognize right to healthy environment, or incorporating the issues of climate change within the framework of environmental laws which are existing. The next problem which I see is the displacement issue, which also I highlighted during my lecture heavily, that there are complex issues which revolve around displacement, climate change induced displacement. And third is what I feel the more important core area, which is access to justice. So, what kind of remedies are available when these issues generally arise? So, environmental violations legally generally affect masses, right? So, how do people have access to justice in such kind of cases is also an very pertinent area which needs to be looked into.
Thank you, ma'am. The next question that I have is, how can we ensure a just and proper transition to a low carbon economy in South Asia?
So I had a specific, slide just devoted to the countries having their target. You could easily make out that the different countries in South Asia have their different priorities as far as their targets are concerned with regards to being a low carbon economy. So, what we can generally do is to have a legal and policy framework which promotes more usage of renewable energy and trying to phase out fossil fuels. But at the same time, it should not be at the cost of violating the labor legislations, right? And it could be also done through regional cooperation. So if the South Asian countries collaborate with regards to creating a legal framework to manage their cross border environmental and social impacts, that would actually create a lot of difference. And maybe this could be also done by sensitization, by involving a lot of affected communities, especially the marginalized groups, and by maybe having a climate education, like a climate change education, incorporated in syllabus to have a sort of onus which lies on everyone to ensure that there is low carbon economy. We can maybe slowly move towards that in future.
Thank you, ma'am. And I understand that these questions are already dealt in your presentation, but I would just request if you could summarize it,
Yeah,
like for
definitely. No
the
problem, Abhinav.
yes.
No problem.
Then the next question is, how can environmental laws affect international trade agreements?
Okay. So see, environmental law and trade agreements. So you have an international trade law, right, which governs this particular area. So if you look at it from that perspective, countries may impose trade restrictions on certain goods which do not meet environmental standards, which maybe affects the export and import of goods. And environmental regulations may be laid down with regards to emission standards, and they can sort of act as a non tariff barriers, or which can complicate the diplomatic relationships between countries with regards to having trade negotiations. Dispute settlement is also one of the area where they are correlated, because disputes will arise if environmental laws are seen as violating the trade agreements. For example, the WTO has addressed cases where environmental measures were challenged as unfair trade practices, right? And then modern trade agreements generally today also include a lot of provisions which balance trade liberalization on one hand and environmental sustainability and environmental protection on another hand. So that is how environmental laws can affect international trade agreements.
Thank you, ma'am. Then the next question is, how can international policies be designed to ensure that climate change mitigation efforts also protect and promote the human rights of vulnerable communities affected by environmental degradation?
So, as I stated, having a strong human rights based approach, so integrate human rights, incorporate human rights principles into climate change policies and actions, prioritize human rights, ensure that human rights considerations are prioritized in the decision making process. Now, in constitutional law, also we have this debate that to what extent in the constitution making processes vulnerable groups are incorporated. So, because constitutions are also an important means of incorporating right to clean and healthy environment as a right, so that can be done through the mechanism of constitution making process as well. And maybe by having a participatory governance, because at the end, when I was concluding, I did talk about it, that let us have a participatory governance where you respect the rights of indigenous communities who are disproportionately affected by climate change, and ensure that the process of consultation is transparent, there is accountability, by recognizing that certain genders might be more affected by climate change. For example, women and girls may be more affected by climate change. We are now having studies with regards to how it can affect reproduction, how it can affect menstruation, how it can affect the way in which they function, right. So therefore we can have a sort of a coordinated efforts between government, international organizations, and civil society to ensure that there is coherence and there is effectiveness with regards to this issue.
Thank you so much, ma'am, for such an insightful answer. Uh, I think we are done with the questions. Ma'am, in closing, we extend our heartfelt gratitude to you, ma'am, for accepting our invitation and delivering such an informative session. We trust that our audience found it both interesting and knowledgeable. And thank you once again, ma'am, to come and deliver this lecture. And we eagerly anticipate the opportunity to host you again. And thank you all the participants for joining into the session. Thank you so much, ma'am.
Thank you, Abhinav. Thank you, Ayush.